Hi everyone, welcome to the Lawcast. My name is Melanie Thorley and I'm the Director of MJT Law. Today we are going to go over a couple of, let's just say there are some mad cases out there. So first of all, I'm going to be talking about an employee didn't have their contract renewed. This happened only a couple of weeks ago, or a few weeks ago. The employee didn't have their contract renewed. They complained and made an unfair dismissal application. Now, the employer put a jurisdictional objection in that this employee wasn't terminated. And the Commission had to decide on whether a contract coming to an end and not being renewed is a unfair dismissal. Now, there are some terms in the Fair Work Act that talk about contracts coming to an end as not termination. So the question was whether the renewals in the past meant that this employee had essentially a right to have their contract continue to be renewed. Now, the Commission in this case, the Commission said that absent of any relevant mitigating factors, if the parties to a contract of an employment genuinely agree that the employment of that employee will end in particular circumstances, and it does so end, the termination occurs by reason of the agreement between the parties, and there will be no termination at the initiative of the employer. Now, why am I talking about this? Because this seems like a go-figure moment, right? It's because someone actually filed. It's because we've got employees out there who have their contracts who come to an end because there was a term in that contract that said your contract's going to come to an end, and they still feel it's unfair that their contract comes to an end, and they file an unfair dismissal, and it goes through the Fair Work Commission. People have to make a decision on whether the jurisdictional objection of the employee was never terminated, because an unfair dismissal is about termination. And it went all the way through. I haven't had a look to see whether there's any cost application. There was a reserving of costs, that sort of thing. But I just thought it was really interesting that we've got this concept where you can have an employee on a term contract but still complain when their contract ends. Okay, the next thing I'm going to be talking about is there's another bill in Parliament, once again, dealing with the National Employment Standards. This bill was introduced to the Parliament in early March. It's proposing to amend the National Employment Standards, preventing employers from contacting employees outside of working hours unless the reason for the contact is an emergency or a genuine welfare matter. Now, there are a couple of exceptions, but I was thinking about this. How does it work in practice? I mean, obviously this is a bill, it's not in Parliament, it's not in law yet. They haven't looked at particularly at the wording particularly carefully. We've got to go through a whole process, and we all know, well, we may not all know, but there are some of us out there who do know that for years and years there was a bill in Parliament trying to make pay secrecy clauses null and void. And it was blocked and blocked and blocked for about 8 years, and then it expired. And then the Labour government put a bill in last year, fast forwarded it through, and voila, now we have law. So we don't know what's going to happen with this one, but this is an interesting, because it's been called the Right to Disconnect Bill. Now, I have no doubt that there are some employers out there who constantly contact their employees when they're off work. And we're not talking about just being sick or just being on holiday. We're talking about when they go home for the day. That they're getting emails, they're getting text messages, that they're required in many ways, or there's this unspoken requirement to have their emails on their phone, so if something comes up, they'll deal with it. And look, broadly speaking, when you're at work, you're at work. When you're at home, you're at home. And I don't see anything wrong with that. Although I don't have children, I do wonder about this homework bizzo at schools then. If adults have a right to disconnect from their workplace, it does make me wonder why children don't have a right to disconnect from their school environment. They're at school almost the same number of hours as adults are at work. And some would argue that they do far more work with the homework requirements than adults do. So I am interested to see why this is playing out in an adult world first. But I'm fascinated to see how it works in practice. And in a case of an emergency or genuine welfare matter, now, is an emergency when an employee calls in sick and you've got to cover that roster? Is that an emergency? Is it an emergency when the employee goes home for the day, says they might not be in on Monday, and you want to check in to see if that's actually going to be the case because they're not feeling very well, for instance, or something else? I mean, what's an emergency here in this case? So I'll be interested to see how this actually plays out in reality. But, needless to say, it's another bill. Labor government's making some more changes to the National Employment Standards, and this is one of the ones that they've proposed. We'll have to wait to see if the bill gets passed. Now, the next thing, I know I'm just kind of speeding through it today, the next thing I wanted to talk about is this question of being terminated by mailbox. Now, I don't know who does snail mail these days. I have to send out letters because of requirements in my law practice, but it's quite rare for me to receive a letter in my personal life. In this case, the employee has provided a physical address that's not theirs. The employer knew it wasn't theirs, and it was apparently their dad's or I think it was their dad, or their dad was elderly, and they knew that person checked the mailbox, but they knew that person didn't live there. They wanted to terminate this employee, and I'm just going to use arbitrary dates. So they wanted to terminate this employee on the 1st of March. They drove over to this house, popped the termination letter into the mailbox, and then, left. They did it like 3:30, 4:30 in the afternoon. The next day, the employee receives further correspondence that they are also terminated. I think this is by email or text message. Now, the employee files an unfair dismissal application. I'm not going to go into the issues on that. But they file it 21 days to the day after they receive the email or text, the next day on the 2nd of March. And the employer argues that they were actually terminated on the 1st of March because they provided this letter. Now, the Commission considered this. They considered the circumstances around it. Now, I don't know about you, but I check my mailbox. Well, I don't check it every day, but if I did, it wouldn't be at random times in the day. I might check it in the morning, for instance, or I might check it at midday. In this case, the applicant's dad was in a wheelchair. He checks it around 10:30 as he's walking out the door to do something, and he doesn't look at it again for the rest of the day. So in fact, the reality is that mailbox wasn't checked at 4:30 when it was posted. In fact, it wasn't seen until the next day. And the Commissioner didn't agree with the employer that they had validly terminated that person on the 1st of March. The employer knew, and the Commissioner said the employee knew that the employee didn't live there, that the resident in the house had mobility problems, and a text confirmed the termination wasn't sent until the next day. The Commissioner apparently wasn't amused. He confirmed that the termination was not effective until the next day and actually let the application through. So I guess the moral of the story here is if you're terminating someone, make sure they know it. Make sure they actually know it, not just pop something in the mailbox and hope that they receive it. These things, it's not just as simple as putting something in the mailbox anymore. People don't check their mail multiple times a day, and if they are certainly alone. There would be the minority in the public. Okay, well, I'm going to talk about just one more thing if we've got time. And that's another change to the Fair Work Act. Now, this is a really strange one. The federal government is looking at making some changes to anti-competition. And this kind of concept that restraints of trade are stopping employees from going out and finding really good jobs. Now, non-compete or no-poach restraints are used in companies to protect the confidential and proprietary information, to stop employees from going to different companies and poaching their clients and poaching information and just getting up to basic mischief. Now, there is this kind of, I guess we can say whispers that the federal government's not liking this. Look, this is completely insane in my view. The restraints clauses are unenforceable until the court enforces them. Only a handful of restraint clauses get enforced, and that is because there is a genuine need. Restraints, for a start, are an incredibly complex area of employment law, and restraints will only be enforced by the court if it is absolutely necessary or reasonably necessary to protect the employer's legitimate business interests. And why can't an employer protect their legitimate business interests? Why would one make a determination legislated to say that these clauses are unenforceable? I simply don't understand it. So we'll have to see how that plays out. I actually don't know what's going to happen on this one. I think it's a little bit, it's a bit of a mad thing that they're talking about that they'll never really actually do, but it's certainly worth keeping an eye on and seeing what's going to happen, because as an employer, almost every contract has a restraint in it of some level. And yes, most of them won't be enforceable if something happens, because it is always a very specific set of circumstances, and it is about business efficacy and legitimate interests. And it is not sensible if you've got a warehouse worker moving boxes around, that they can't go and work for a competitor to go to a warehouse and move boxes around. So that restraint would never really, in my view, would ever be enforceable. But if you've got a salesman who's been working with your clients for literally years, have built intimate relationships with these people, I'm not saying it's a funny intimate relationship, but they know them really well, they've been going out, they've been hanging out with them, and then they leave, I don't see anything wrong with stopping that employee from taking those clients with them, because they belong to the employer, they don't belong to the client. So look, there's some interesting ones here. We've got 2 law changes which seem a little bit like using a sledgehammer to thread a needle, and we've got 2 cases which seem really weird. Why would you think that terminating someone by driving over to their house and popping it in their mailbox, they're going to receive that termination notice? I don't understand that. And an employee who thinks that it's okay to argue unfair dismissal when their contract was already coming to an end. What? Anyway, hopefully you're all going to have a lovely week. Thank you for watching the Lawcast. It was a lot of fun today. Hopefully it wasn't bang, 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 bang too much. And we'll catch up with you in a couple of weeks. See you later.